I think we should work now. Yeah?
Yeah.
Yeah. Our topic today, legal responsibility and liability. Legal responsibility and liability. When do you hear something about this lecture, about this topic? Don't you remember? When? At our first semester or second? Don't you remember? First? First. Oh, I mean, you're Ukrainian, yeah? Lectures in Ukrainian language. Okay, so it was first semester, and I hope that you remember something like usual, yeah? So, legal responsibility, and of course, we have some questions. First question, social responsibility. And we'll go from general ideas, yeah, to some parts of this idea, okay? That is why first question about social responsibility and its types. Second question, legal responsibility and liability, and here we'll speak about notion of the legal responsibility and liability, the difference between responsibility and liability. Hello, Camille. Then, of course, we'll speak about types of legal responsibility. And the content of this second question. Yeah. Then, third question. Principles of legal liability. And what fourth question? Branch types of legal liability. And I think you can understand that legal liability is more important for jurisprudence. Yeah, maybe. I'll explain a bit later what is the difference between legal responsibility and legal liability. Because the translation of this word to Ukrainian, yeah, the same. I think you know this, yeah, responsibility and liability. But we have a bit different sense, yeah, of these words. Okay, first question. What is social responsibility? What is social responsibility? It's some requirements, yeah? Requirements of what? Maybe you can say something. Requirements, yeah, of society and for what? For some behavior. Yeah? So, social responsibility is a requirement of society for the behavior of individuals, or maybe not individuals, yeah? It can be their associations, which includes the duty to report on their behavior, which includes the duty to report on their behavior. I think should be better. And it is supposed that everyone is responsible to act in beneficial manner to society. Yeah? And not solely to individual. Solely, yeah? Do you know this word? Solely. It's like only. Yeah. Okay. So, of course, we'll speak about legal responsibility from the position of the general theory of state and law. Yeah, and that is why we'll speak about theory of social responsibility. Yeah, and what is this? The theory of social responsibility is built on the system of social norms. The theory of social responsibility is built on the system of social norms in which decisions and actions must be ethically validated before proceeding. Must be ethically validated before proceeding. I see that you are going to write all my words. It's pleasant, but you shouldn't. Yeah, you mustn't write every word. Yeah, of course, I can repeat the theory of social responsibility, yeah, is built on the system of social norms in which decisions and actions must be ethically validated before proceeding. Must be ethically validated before proceeding. If the action or decision causes harm to society, yeah, or maybe not society to environment, yeah, then it would be considered to be socially irresponsible. Yeah, socially irresponsible. Okay, so social responsibility is manifested in two aspects. Two aspects of social responsibility. What is this? First aspect, I think it's important moment. Responsibility as readiness to act in accordance with social norms. Yeah, readiness to act in accordance with social norms. Maybe you don't think about the responsibility from such point of view. Yeah, am I right? That it's like readiness, and we just do something to the accordance some with some social norms or maybe moral norms or maybe legal norms and so on. Yeah, I think you thought about responsibility like some liability. Yeah, liability. And here I think you can feel the difference between responsibility and liability, yes? Because liability, it's like some sanctions, yeah, because of not accordance with social norms or legal norms or moral norms or something else, yeah? Or maybe religion norms, yeah, religious. Okay, or just religion. So, social responsibility in this way is a kind of ethical theory, yeah, and in which individuals are accountable for fulfilling their civic duty. The actions of an individual must benefit the whole of society, benefit the whole of society. And for example, let me remind the words of Pope Francis. Yeah, Pope Francis. I think you know who is this. Yeah, and I have a little quotation. Responsible citizenship is a virtue, and participation in political life is a moral obligation. Yeah. You shouldn't write this sentence over this idea from the Pope Francis, but I think we can explain such understanding of the responsibility from the point of view that responsibility just a readiness to act, yeah, with some social norms, yeah. Okay, and second understanding, yeah, second aspect. I said that we'll speak about two aspects, yeah. Second aspect, liability as a public assessment of the individual's behavior that deviates from positive to negative. Yeah. And here we can speak about some negative behavior. Liability as a public assessment of the individual's behavior that deviates from positive to negative. And here we can give some estimation, yeah, of the behavior, of the individual's behavior. And again, this behavior can be positive and can be negative, of course. Okay, if you don't have any questions, we can turn to our next very important thing, and it's types of social responsibility. And here, I think you remember something. Types of social responsibility. I said about these types already, like some examples of the norms of social responsibility. Yeah, I mean this. Yeah, you're absolutely right. So the types of social responsibility include moral, yeah, religious, political, if you want, responsibility, artisan. It's like responsibility in political party. Yeah. Legal responsibility, of course. Here we should say about this legal responsibility too. Yeah. So what is moral responsibility? Moral responsibility. What is the criteria of the moral responsibility? Maybe you know? It's difficult. Yeah. What? Behavior of a person? Yes, of course. But behavior of a person, we can use like some criteria for moral, religious, political, yeah, and another types. Again, please.
If we talk about moral, we have no sanctions, no legal.
Yeah, of course, we can't have some sanctions like, for example, in legal responsibility, but it's a difference, yeah, between moral and legal responsibility. But what is criteria for moral? I think it's interesting, and moral responsibility means the willingness, willingness to act in accordance with the norms of morality. Yeah, so our criteria, just norms of morality. And what is norms of morality, or what is the main value of the moral? And here we can, what do you want to say? No? So moral values, it's just a distinction, yeah, create a distinction between right and wrong, yeah, just and unjust. I think it's very difficult to feel this criteria, yeah, between wrong and right, because any subject, any individual can have absolutely different understanding what is right and what is wrong. Yeah, it's difficult, but when we try to speak about some group of people or country, yeah, or state, here we can speak about this criteria, yeah, because some people have maybe similar understanding what is right and what is wrong. And it should be noted that usually moral responsibility is exercised voluntarily. For example, for example, um, I have interesting example, and I'll read this about information about this example. President of Mauritius, it's small island African country. Yeah, Emin Turib Fakim resigned due to financial scandal. Yeah, and here we can speak about some moral characteristics of this resigned. Yeah. Why? I'll explain. Curry Fakim was accused of having used for private purpose the bank card of the non-governmental organization. Yeah, it was, it was she. Yeah. She spent more than 25,000 euros for buying jewelry and luxury things. This card was received to cover her travel expenses related to her activity. She used card by mistake, yeah, but immediately returned money. But of course the organization confirmed their fund, but she lost trust of the citizens and resigned voluntarily. Yeah, and here we can see such mistake, yeah, of official person, yeah, or of official subject. But she lost some trust. Yeah, she lost some trust, and that is why, of course, she must resign voluntarily. Yeah, it's moral. Yeah, characteristic of some responsibility. In case of violation of morality, individuals can be punished by, I just want to say about the sanction, yeah, some sanction of the moral responsibility. What can it be? It's public condemnation. Yeah, do you know what is this? Yeah, the public condemnation, or it can be boycott. Yeah, you know this word, or just mockery. Yeah, mockery. You know what is this? Mockery. Mockery. Don't you know? No? Як насмішка. Підтрунювання таке, так? It can be like a little sanction, and of course, but it's not sanction. Yeah, you cannot say that it's sanction in the sense of legal responsibility. Yeah, it's something light. Yeah. But of course, some final situation can be very, very not can be worse, yeah, for some individuals or even not individuals, maybe group of some people. So next responsibility, next type of social responsibility, it's political responsibility. Political responsibility. And here, what can we say about the political responsibility? Of course, political responsibility is readiness of a conscious politician to act in accordance with the political norms. Yeah. In the case of violation of the political rules and public morality too, because here it's very important in the sphere of politics, yeah, public morality. I think you can understand this. For example, it can be non-compliance with political agreement, non-fulfillment of promises made to voters, yeah? Or, for example, improper moral image of politics, something like this. So, and what can we say about some sanction in the sphere of political responsibility as a result of some not good things in the sphere of politics? What can it be? Political responsibility may be expressed again, in boycott. Yeah, it can be especially of immoral politicians. Yeah, I think you remember the situation with the Bill Clinton. Here? Yeah, yeah.
It depends on what crime the politician does.
Yeah, it was not crime, I think. Yeah, and again, maybe it was some not good. Not good for him. Yeah, and not only for him. And firstly, it was again the immoral, yeah, behavior, just immoral behavior, and of course that is why again he must resign, yeah, from his post, from his position, yeah. Then I should say about the some what I mean, yeah. Maybe you remember the last situation with Vladimir Putin, yeah, and we have some document, yeah, and as a result, this public person can be called non-handshakeable, yeah, non-handshakeable. But of course, it was illegal behavior, yeah, from his position, illegal, immoral, and of course, it's a political responsibility too, yeah, and that is why non-handshakeable. Then another not example, but type, yeah, type of political responsibility. I mean partisan responsibility. Yeah, we have the word party. That is why we have partisan responsibility. What is this? Is a kind of political responsibility again, and it means that every member of political party must act in accordance with the program of this political party. Yeah, program or statute of this party. And if somebody who has some rights and duties in this party, yeah, don't do some right things from the rules of, from the position of the rules of this party, yeah, and this politician can have some partisan responsibility. And what can it be? What do you think? Yes, and yeah, the most severe, yeah, punishment for this member of the party is just exclusion, yeah, from this party. Okay. Next responsibility. Next type of the responsibility, corporate responsibility. Corporate responsibility. And again, corporate responsibility means readiness to act in the in accordance with the rules of some organization. Yeah. And in case of violation of corporate norms, a guilty person is fined. Yeah. And corporate liability can result in fines or maybe not only fines, yeah, maybe just passing of some bonus, yeah, in this organization. Or again, like with a case like in our previous example, yeah, it can be exclusion from corporation. Yeah, exclusion from corporation, like exclusion from the party, from the political party, and etc. So, next responsibility, religious responsibility. What does it mean? The religion responsibility means the willingness to adhere to religious dogma and norms. Yeah, it's like a positive part of this responsibility, and negative, and yes, and in the negative sense applies to believer who violates the requirements of religious norms. And this may involve imposing additional duties. For example, reading prayers, yeah, above the mandatory number. And for example, it can be excommunication from rituals. Or expulsion from the church. Yeah. Okay. It's a religious responsibility. Maybe somebody is religious person. Have with some religious person or not here? Yes, why not? And that is why you should know about this responsibility. Yeah, religious responsibility. Okay, and last type of the social responsibility, of course, legal. Yeah, legal responsibility or liability. What is this? Of course, is a type of social responsibility, and it is based on the legal requirements. Yeah, legal requirements that, if it's necessary, are provided by state coercion. Yeah, by state coercion, or maybe even by coercion another body that has received such a power from the state. Yeah, I think you can understand what is the legal responsibility, but of course we'll speak about legal responsibility more. So it was our first question. If you have some question, you can ask. No?
No question.
Perfect. So our second question, and our second question was legal responsibility and liability. Yeah, and here we will speak about this difference about legal responsibility and liability. And I hope that you remember that we have positive legal responsibility and negative legal responsibility. And if we will try to speak about positive legal responsibility, positive legal responsibility has prospective and retrospective aspects. Yeah, prospective and retrospective aspects. So positive responsibility is personal attitude to unconditional exercises of legal provisions. Is personal attitude to unconditional exercising of legal provisions. It's and this is positive. And this is an element of normal healthy legal awareness. It's normal for individuals or a group of people to do something in such a way. And such person is called responsible person. Yeah, it's just responsible person. Are you a responsible person or not? Yeah, of course. I hope. So, and retrospective aspect of positive legal responsibility is a positive legal assessment of the merits of a person. Is a positive legal assessment of the merits of a person. And here we'll speak about some hallmark of positive retrospective legal responsibility. Some hallmarks of positive retrospective legal responsibility. What do you know about these hallmarks or features, if you want? We can say about this word here of positive retrospective legal responsibility. Okay, firstly, we can speak about this type of responsibility without legal norms. Yeah, that is why first, it is a set of incentive legal norms. What is this? It is mean. Yeah, incentive. What is this? How can you translate this word incentive legal norms? Okay, it is mean of legal persuasion. Yeah, legal persuasion and legal incentives. So what is incentives? Yeah, like some stimuli, yeah, to do something. And persuasion, you're absolutely right. Убеждение. And in Ukrainian, переконання. Yeah, thank you. I think we can define all the words, yeah, here, and we can turn to next feature, yeah, or hallmark of the positive retrospective legal responsibility. So second, it is applied by specially authorized entities. It is applied by specially authorized entities. And can you name these entities? Special authorized. No, I'm sure that you can. Yeah, it's state bodies, yeah, or bodies of public authority. Yeah, and can be some managers on or every or some owners, yeah, of some enterprises, organization, and so on. For example, President of Ukraine has the authority to award citizens of Ukraine with the award for special merits. Yeah, and today we can see, yeah, this very often. Yes or no? Yes, it's time for this. And next hallmark, it means giving the person additional rights, additional opportunities, and other social benefits. And the examples, yeah? Some additional rights, opportunities, and benefits. It's positive retrospective responsibility. And for example, what can it be?
People with some perks, for example.
With some what?
Perks. People, работающие.
Yeah, some benefit again. Yeah, I said about this benefit. Um, for example, it can be cash bonus, yeah, or promotion of the position, yeah, in some enterprises or status. Yeah, you're absolutely right. But it's position. Yeah, the right word here is position. Then gratitude announcement. For example, presentation of some diploma. Yeah, it's level up. Yeah, and we're awarding honorary title. Yeah, awarding on an honorary title, and so on, and so on. Next hallmark, it is carried out in compliance with procedure. Procedure, both revealing the effect of merit and the awarding. Some procedure, yeah. In compliance with procedure. It is carried out in compliance with procedure. Both revealing the fact of merit and the awarding. And last feature or hallmark, the reason of application is a merit of the person. The reason of application is a merit of the person. The merit is an act of socially useful behavior that exceeds the requirement for lawful conduct. Requirements even. And here we can speak about feat, some self-sacrifice, recusing another's life, preventing the violation, outstanding results of work or creative activity, or charity even, yeah, and etc. And now I want to turn to types of positive retrospective legal responsibility. Types of positive retrospective legal responsibility. And we speak about some examples, yeah? And we spoke even types of positive retrospective. It was hallmark, yeah? And now types of positive retrospective legal responsibility. And first, it's award for special merit. Award for special merit. And for example, again, we we say here about the state award of the president of Ukraine. Then, second, criminal legal incentives. Criminal legal incentives. I'll explain. A person who committed a crime may be released in case for further lawful social useful behavior. Yeah. For example, it can be victim offender reconciliation. Yeah, victim offender reconciliation. Do you know what is a reconciliation? No? Victim offender. Yeah, and here you can understand already what can it be. Reconciliation, примирение. Yeah, victim offender reconciliation. Then, voluntarily surrender of weapons. Etc. Okay. Third, yeah, type of positive retrospective legal responsibility, criminal enforcement incentives. Criminal enforcement incentives. And I'll explain. Criminal enforcement incentives apply to persons serving prison sentences. Yeah. For the commission of merits or for a long, faithful fulfillment of their legal obligations, and as a rule, expressed in the form of early or partial release from further punishment. Okay? Did you understand me or not? Or so? Yes, I hope. Okay, then fourth, labor-induced encouragement. Labor-induced encouragement. Encouragement, what is this? Labor-induced encouragement. In Russian, поощрение. And in Ukrainian, заохочення. You're absolutely right. Labor-induced encouragement. What is this? The positive responsibility is applied by the employer to employees for the diligent performance of labor duties or over fulfillment of labor standards. And it may be expressed, for example, in monetary price, yeah, or again, honorary certificate, yeah, certificate. It's labor-induced encouragement. Then, disciplinary incentives. Disciplinary incentives. Disciplinary incentives are applied for exemplary discipline. Yeah, exemplary discipline. Accuracy and the speed of execution of some instruction. Yeah, and etc. The state and military service and consist of the assignment of the next rank, next class, awarding breastplate, yeah, etc. Okay. And last type, financial and economic incentives. Financial and economic incentives are applied in the sphere of economic activity by the state to economic entities for achieving their high economic indicators. or high activity in the field of philanthropy. Yeah. Assistance in the implementation of state programs and etc. It's financial and economic incentives. Do you have any question or not? No? Okay. And negative attitude of the person to law and legal provisions, or for example, neglecting law, violation of legal norms is regarded as irresponsibility. Yeah, irresponsibility. Thus, the prospective aspect doesn't have a negative responsibility. And negative responsibility, negative retrospective legal responsibility is called liability. Yeah. So what is liability? Negative prospective legal responsibility. Yeah. What is liability? Did you hear? Perfect. It is carried out within a special procedure. The bearer of legal liability must suffer partial deprivation or limitation of personal rights or even property. Yeah. So the hallmark, some hallmark of liability. Hallmark of liability. What is this? Maybe you know. I think you must know something about some features of liability. What is the main feature of legal liability? Hmm? Students, are you here? Yeah? Are you with me or with your telephones? Yeah, of course. Some sanctions, some state coercion. Yeah. Perfect. And something else. Okay, firstly, a hallmark of liability. It is based on state coercion. Yeah, coercion that is implemented through the activities of special state bodies. And what is the name of this special state body? Or even what are the names of these special state bodies? Oh, just police, yeah? Yeah. Or state penitentiary institutions. Yeah. Or executive service. And so you are right, of course. Or other entities authorized for this activity by the state. And in some countries, it can be some private, even penitentiary institution. Yeah, I hope that you know that in some countries, we could speak about this. Some private, yeah, penitentiary institutions in some countries. Okay, there exists, especially for minors, Yeah. Then next, hallmark. It causes certain negative consequences for the offender. Yeah. Certain negative consequences for the offender. Which are expresses in personal limitation. And again, for example, what can it be? Some restrictions, some deprivation. Yeah. Okay, deprivation of the right to engage in certain activities. Or, I don't know, confiscation of property. Yeah, if it's some property charges. Okay, next feature or hallmark of liability. It is the reaction of power subject to antisocial behavior. Reaction of the power subject to antisocial behavior. And here we should remember the thoughts, feelings, desire to commit offense cannot be the basis of what? Some thoughts, some feelings, some desire to commit offense cannot be basis of legal liability. Yeah, because if we feel something, yeah, it's not the cause of legal liability. Yeah, it's just our feelings, our thoughts, and so on. Okay, and next hallmark, fourth. Yeah, it has a procedural form. Procedural form. It has some procedure. So legal liability is exercised by competent authority of the state or other publicly owned entity in strictly accordance with the legal procedure. And here, of course, we can speak about some codes, yeah, in our legal sphere. Yeah, and of course, some branches of law, which with such procedure. And it can be criminal procedural law, yeah, or criminal procedural code, yeah, or civil, and so on. And last hallmark, the actual ground of liability is an offense of a delinquent subject. Delinquent subject. I didn't remember this word. Delinquent subject. Yeah, правопорушник. The actual ground of liability is an offense of delinquent subject. I think it's very, very important moment. So, some classification, yeah? Some classification of negative legal responsibility for its main goals. Classification of legal responsibility for its main goals. Firstly, reparative or restorative. Reparative or restorative. We have two types of the negative legal responsibility, and it's restorative or reparative, and unitive, yeah, or repressive. Reparative and repressive, unitive, yeah. Yeah, right. And what is difference between reparative and this punitive responsibility? Can you explain or not? No? Okay, I'll explain. The big difference between this classification that we have some rights again in the case of reparative, yeah, responsibility, and as a result of the punitive responsibility is some sanction, yeah. That is why reparative execution by the offender or additional positive duties in favor of the victim of the violation. It can be person or legal entity. So the person who committed the offense reimbursed the committed harm, restored the violated rights, performs duties, terminates of an unlawful act without the coercion of the state. For example, there is contractual civil and financial liability. Contractual civil and financial liability. And here we should say that this type of liability, I mean reparative liability, is like characteristic for civil relations. In the sphere of civil law. And of course, punitive or repressive liability is characteristic for what? Law. Not civil, but criminal, of course. Criminal. So, about a few words about reparative liability. Here I should say that liability is considered to be the one that came after performing the duties of the offender. And state coercion is applied in case of a conflict between the parties of the legal relationship. So here we can speak that even state shouldn't be the subject in this reparative responsibility. State can be like a subject, but not in the all cases. Only if we have some conflict between the parties, in this case, yes, of course, it can be state coercion. Okay. So punitive. The person who committed the offense is persecuted or sentenced on the basis of a decision made in accordance with the procedure established by law. And here, of course, we should speak about criminal responsibility and better, we should say criminal legal liability. Criminal legal liability or administrative legal liability. It can be too administrative. And until now, this type of responsibility was seen as the main one. But the idea of restorative justice and reparative liability worldwide has led to critical think of the possibilities of this form of legal responsibility. I think you can feel this approach maybe in the sphere of jurisprudence, that we should try to use restorative liability more than the punitive liability. Okay, perfect. And it should be also be noted that the context of civil society and rule of law, and the importance of legal liability increase. Taking into account the general tendency toward humanization of legal influence. I think you heard about this idea. I mean, humanization. Humanization of legal influence. And in case where the violation of human rights is caused, the priority task is the restoration of violated rights, maybe even compensation for damage by the offender. I think you know some examples here of this compensation, and we many times spoke about these examples of financial compensation or refund the financial damages, something like this. However, I should say that punitive liability plays a significant role in ensuring law and order and protecting human rights too. Yeah, maybe if it's a very good idea, the prevailing, or I don't know how to say, maybe prevailing, of the restoring liability, but we should and we must use the punitive liability too, because we have some causes for this, and we have some cases for this. Okay, and do you have any question or not about this restorative, punitive, and some philosophical idea about restorative and punitive responsibility and importance of this restorative idea in our legal sphere? Okay, if you don't have any question, we can go to the next question. And our next question about principles of legal liability. So let me turn to the first principle. First principle, the principle of legality, or strict compliance with law. Strict compliance with law, legality. What is this? What is this principle of legality? So the components of this principle are the following provisions, and legal liability should come only for behavior. I said about these moments already, not for thoughts, for worldview, your feelings, or, for example, personal qualities. This is not the cause for implementation of this principle. So the actual grounds for the application of such measures must be determined and, of course, proved. We should have some proofs for some liability. And responsibility is legal if it is carried out in accordance with the relevant rules of procedure. Only relevant rules of the procedure. What is relevant? Do you know? You are absolutely right. Відповідні. And that is why we have such principle of legality or strict compliance with the law. Then, next principle, the principle of justification. The principle of justification. You are like a future lawyer, should know about these principles, and of course you should work in your future with these principles only. The principle of justification is expressed is establishing the very fact of the merit or the fact that offender commits an unlawful act, as well as the establishment of other relevant facts related to the conclusion about the actual grounds of liability. I have some example. For example, in our Constitution, we have article number 62. And the name of this article, and you should that in this article lays the fundamental principle of negative liability, and this principle is presumption of liability. Yeah. Oh, sorry, liability. Presumption of innocence. Presumption of innocence. Yeah. Did you understand me? Perfect. And here we should know about this principle, and we can read: a person who is persecuted is considered innocent until his or her guilt is proved and established by the relevant law enforcement act. Yeah. But the application of positive liability must be well-founded. Merit should be real, not imaginary or fictitious. Otherwise, state awards and other incentives are devalued. Yeah, it was that content. I didn't give you some quotation of this article, but explanation, yeah, of this article with the name, yeah, with the content of presumption of innocence. I hope you remember this idea. Don't you have any question? No. Okay, third principle, the principle of justice. Yeah, the principle of justice. And what is the content of this principle? What does it mean? Справедливість. Justice. Justice. Yeah. The principle of justice means the fact that liability must be appropriate. Yeah. Must be appropriate. Proportional. Yeah. Proportional action. This principle is very important. And this principle is important both for positive and negative responsibility. Why? No, I think you know that if we will give some rewards, yeah, to some person, and this person didn't do something good, yeah, it will be not good for other persons too, because they will think, why, yeah, why these rewards are not for me. So both rewards and punishment should be proportional to the behavior of the subject of responsibility. Yeah. And for example, for negative legal liability, and this also means that for the same offense, the offender shouldn't not be held liable twice. Yeah, I think it's very, very important. Then measures of punishment and enforcement shouldn't degrade human dignity. And victims of the offense must take measures to restore its violated rights and meet its needs. So I think you can understand this principle. It's not so difficult for your understanding. And of course, we should think about this equal, yeah, between some positive or negative liability, or some rewards and punishments. Next principle. Next principle of expediency. Expediency. Don't you know this word? and it's доцільність. Доцільність, expediency. And this principle involves the choice of the most optimal option of legal liability. Yeah, optimal. I mean, economical and at the same time, time effective. Yeah, economical and time effective. So in particular, the person who committed the offense must identify the measures of responsibility necessary and sufficient for its correction and prevention of the commission of new offenses. Okay, and next, not principle, but idea, and a very important idea in the measures of this principle, if the purpose of the punishment can be achieved by alternative measure, yeah, the measures of liability can be mitigated or even cancelled. Yeah, mitigated or even cancelled. It's principle of expediency. Maybe it's not so understandable what is expediency and why should we do our work, our judicial work, yeah, or work in this sphere in jurisprudence from the positions of this principle, but we should, yeah, and we must. So and here I should say that rewarding of encouraging are not subject to such rigid requirements, but the principle of expediency also applies to this type of responsibility. And for example, the reward should be adequate, yeah, to the merit that is required by the rules of the statutes, the right word in this case of stated words. Okay. So next principle. And I think it's very important principle too, because it's principle of timeliness. Principle of timeliness. How can we translate this principle? Yeah, you're absolutely right. Timeliness, because you know that we can be without any sanctions after some time. Yeah, and that is why the principle of timeliness implies and operational response of the state or other authorized entity to acts of conduct, which is the actual basis of legal liability. And regarding the negative legal liability, this means possibility or bringing the offender to liability only for a certain period. Yeah. Until the expiration of the limitation period. Of course, it depends, and depending on the severity, yeah, severity of the offense. I hope you know this word, yeah, severe and severity of the offense. And on the contrary, the expiration of this period results in the release of legal liability, which is expressly provided by the administrative, criminal, labor law, and so on. So we have some different periods, yeah, for some sanctions. And of course, if we will speak about labor law, it's not so long period, yeah. In the sphere of administrative law, again, maybe a bit more, yeah, time for this period, but not so long. But She will speak about criminal law and the severe, the type, yeah, of severity of the offense. Of course, here we can speak about liability for some long period, yeah, of time. So negative. Legal responsibility is also a subject of principle inevitability. Yeah, inevitability. Principle of inevitability. Negative legal responsibility, and of course, we should speak about here. Yeah, we should speak about the principle of inevitability. And you know what is this inevitability?
Yes.
Yes. А? Yeah. Неминучість, невідворотність, you are absolutely right. Which means that every offense, ideally, inevitably entails a penalty. Yeah, of course, ideally, yeah. No offense shouldn't be left unended by the state and society. And of course, the offender must necessarily be addressably, yeah, I don't mean this word, I mean the word adversely affected. Adversely affected. Okay, we haven't time. Of course, I'll send to you this lecture and you'll read the last question about the branch types of legal liability. Don't you have any question? Thank you for your attention. It was very pleasant for me.